Hello, bonjour et bienvenue. Je suis ravi que vous ayez pu joindre à nous aujourd'hui. Ce matin, la Cour suprême du Canada a rendu son avis sur la loi sur l'évaluation d'impact et l'événement aujourd'hui est l'occasion pour vous d'entendre la réaction du gouvernement du Canada à cet avis. Je m'appelle Oliver Anderson, directeur de communication pour le ministre Guilbeault et je serai le modérateur de cet événement. Hello and welcome. I'm pleased you're able to join us today. Today, the Supreme Court of Canada provided its opinion on the Impact Assessment Act, and today's event is an opportunity to hear the Government of Canada's reaction to this opinion. My name is Oliver Anderson, Director of Communications to the Minister Guilbeault, and I'll be the moderator for this event. So we will start with remarks from the Honourable Stephen Guilbeault, Minister of Environment and Climate Change Canada, followed by the Honourable Jonathan Wilkinson, Minister of Energy and Natural Resources. After that, we'll move into a question and answer session, which I will get into following their remarks. Alors, nous allons commencer avec le ministre Stephen Guilbeault, l'honorable Stephen Guilbeault, le ministre de l'Environnement et du Changement climatique Canada, suivi par Jonathan Wilkinson, le ministre d'Énergie et des Ressources naturelles. Et après ça, nous allons suivre avec une période de questions et réponses. Alors, so Minister Guilbeault, please go ahead.
Merci beaucoup, Oliver. Thank you, everyone, for being here. Merci beaucoup d'être ici. I would like to thank Minister Wilkinson also for joining us at the start of his day in Vancouver. It's an honor and a pleasure for you to join me. J'aimerais reconnaître respectueusement que je me joins à vous depuis Montréal sur le territoire traditionnel de la nation Kanien'kehá:ka et des autres peuples Haudenosaunee. Today, we accept the court's opinion. It provides new guidance on the Impact Assessment Act, while explicitly affirming the right of the Government of Canada to put in place impact assessment legislation and collaborate with provinces on environmental protection. We developed the Impact Assessment Act to create a better set of rules that respect the environment, Indigenous rights, and ensure projects get assessed in a timely way. We remain committed to these principles, and we are heartened that the Supreme Court of Canada affirmed our role on these core principles. We will now take this back and work quickly to improve the legislation through Parliament. We will continue to build on 50 years of federal leadership in impact assessment. We respect the role of the Supreme Court in Canada's democracy, and we will follow the guidance of the court and collaborate with provinces and Indigenous groups to ensure an impact assessment process that works for all Canadians. Our immediate priority will be to provide guidance to our many stakeholders and Indigenous partners to ensure as much predictability as possible for projects affected by this opinion. We fully understand that we need to act in a timely manner. The Government of Canada wants to ensure clarity and certainty for investment in projects this country needs. This is exactly what the previous Harper government and senior ministers like Pierre Poilievre failed to provide. So now we will return to our homework and commit today to address this quickly and continue to make Canada an attractive and predictable place to invest in good, sustainable projects as we create and protect middle-class jobs and advance on a path of reconciliation. Thank you. Alors aujourd'hui, nous acceptons l'avis de la Cour suprême. Il fournit de nouvelles orientations sur la loi relative aux études d'impact, tout en affirmant explicitement le droit du gouvernement du Canada à mettre en place une législation sur les études d'impact et à collaborer avec les provinces en matière de protection de l'environnement. Nous avons élaboré la loi sur l'évaluation des incidences afin de créer un meilleur ensemble de règles qui respectent l'environnement et les droits des peuples autochtones et qui garantissent que les projets sont évalués en temps utile. Nous restons attachés à ces principes. Et nous sommes heureux que la Cour suprême du Canada ait confirmé notre rôle en ce qui concerne ces principes fondamentaux. Nous allons maintenant travailler à reprendre cette décision et rapidement à mettre en place les améliorations nécessaires à la législation au sein du Parlement. Nous continuerons à nous appuyer sur 50 ans de leadership fédéral en matière d'analyse d'impact. Nous respectons le rôle de la Cour suprême dans la démocratie canadienne. Nous suivrons les orientations de la Cour et collaborons avec les provinces et les groupes autochtones pour garantir un processus d'évaluation des incidences qui fonctionne pour tous les Canadiens et les Canadiennes. Le gouvernement du Canada veut garantir la clarté et la certitude des investissements dans les projets dont notre pays a besoin. C'est exactement ce que le gouvernement Harper et des ministres de premier plan comme Pierre Poilievre n'ont jamais réussi à faire alors qu'ils étaient au gouvernement. Nous allons donc nous remettre à nos devoirs et nous engager aujourd'hui à régler rapidement les recommandations de la Cour suprême et à faire du Canada un endroit attrayant et prévisible pour investir dans de bons projets durables, tout en créant et en protégeant les emplois de la classe moyenne et en avançant sur la voie de la réconciliation. Notre priorité immédiate sera de fournir des orientations à nos nombreuses parties prenantes et à nos partenaires autochtones afin de garantir autant de prévisibilité que possible pour les projets concernés par cet avis. Nous comprenons parfaitement qu'il est nécessaire d'avancer rapidement. Merci beaucoup.
Merci. Thank you, Minister Guilbeault. I'd now like to turn over the virtual floor to Minister Wilkinson to provide remarks. Merci, Ministre Guilbeault. Maintenant, je passe la parole à vous, le ministre Wilkinson.
Thank you, and hello, everyone. Bonjour à tous. Before I begin, I do want to acknowledge that I am joining you from the traditional, ancestral, and unceded territories of the Squamish, the Musqueam, and the Tsleil-Waututh First Nations here in beautiful British Columbia. Today, the Supreme Court of Canada released its opinion on the constitutional reference to Canada's Impact Assessment Act. The court confirmed that the federal government has the authority to legislate in this area, and that environmental matters are matters of shared responsibility between the federal government and provincial and territorial governments. The majority of the court confirmed that Parliament can enact impact assessment legislation to, and I quote the court's decision, minimize the risks that some major projects pose to the environment, unquote. The court found that the Impact Assessment Act is constitutional in part, but that in some instances, the language in the act needs to be more closely tethered to areas of federal jurisdiction. We, of course, accept the direction provided by the court, and we will be bringing forward the necessary amendments. Prior to 2015, under the Harper government's environmental assessment process, projects consistently got bogged down in years-long litigation because the old system failed to take into account how proposed projects could impact the environment and the climate, and it failed to incorporate the concerns, the perspectives, and the aspirations of Indigenous peoples. Good projects simply took too long or simply could not be built. Harper's gutting of Canada's environmental assessment process in 2012 eroded public trust and confidence in the integrity of the system. That is why during the 2015 election, our government committed to work with industry, environmental organizations, and Indigenous peoples across the country to establish a new environmental assessment process and agency, the Impact Assessment Act and the Impact Assessment Agency of Canada, to review major projects. This new process established a set of better rules that would ensure that Indigenous perspectives were included at the beginning of the review process, rules that guaranteed that important environmental concerns were highlighted and were addressed, and rules that provided clear timelines to ensure good projects could be built in this country in a timely manner. The Impact Assessment Act recognizes what the vast majority of Canadians know, that we should indeed be building major projects in a timely manner, and that to do so requires the active inclusion of Indigenous peoples and a focus on environmental sustainability. And while Canada must indeed continue to work to make our processes work as effectively and efficiently as possible, I would note that already many of our international allies look to Canada as providing a model of how regulatory processes should work. In fact, in very recent conversations I have had with both my Australian and my American counterparts, they have told me that they look to Canada to learn how to improve their own regulatory systems. As of May 2023, there are 495 major projects in various stages of development, many of which are critical minerals and clean energy projects that are under construction or planned for construction over the next number of years in this country. These projects have a combined capital value of $572 billion, which represents a 5% increase from 2022 in overall project count and a 10% jump in capital value. Progress is indeed being made. As I noted at the beginning of my remarks, the Supreme Court has found that in a few specific areas, adjustments to the Act are necessary to make it clear that the legislation is more closely tethered to areas of federal jurisdiction. But overall, the court confirmed that the federal government has the authority to regulate assessments of major projects. We will indeed be making amendments to the Act based on the court's guidance. We will continue to focus on upholding high environmental standards and respecting the rights and the interests of Indigenous peoples, all while providing clarity and certainty for project proponents. In the global competition for investment, Canada's project review process can be an important strategic advantage. Such a review process must allow us to move good projects forward in an efficient manner, but one cannot do that by ignoring legitimate questions and concerns relating to the environment and to Indigenous rights. Ultimately, our approach will mean more investments and more well-paying jobs in communities. It means accelerated progress towards ensuring Canada is a global leader in the clean economy. I must underscore that Pierre Poilievre and his Conservative Party want to return us to a time when nothing got built. They want to once again ignore environmental considerations and the rights and the interests of Indigenous peoples. Their approach will create uncertainty and gridlock, which will undermine the future prosperity of all Canadians. This federal government will build upon the work done to date. As I noted, we will be bringing forward necessary changes to the law to align with the court's decision, and we will continue to make project assessment and permitting processes work even more thoughtfully and more efficiently. We will continue to collaborate with provinces and territories as we are doing through mechanisms like the Regional Energy and Resource Tables, where we are talking about regulatory and permitting alignment. And we will continue to work with Indigenous peoples to ensure that they are treated not as passive observers, but as active partners and owners as we build a clean economy from coast to coast to coast. Before I conclude, I just want to acknowledge and thank the many interveners who stood with the federal government to defend this crucial piece of legislation, ranging from my province here of British Columbia to 11 First Nations, to the First Nations Major Projects Coalition, and to numerous environmental organizations. And to the provinces and territories who brought this lawsuit forward, I would suggest that we collectively commit to this being the last time we look to settle our differences in court. Le Canada fonctionne mieux lorsque les Canadiens travaillent ensemble. Canada works best when Canadians work together. Ayant travaillé il y a plusieurs années pour la province de la Saskatchewan, je suis parfaitement conscient de l'importance de rechercher activement et de manière exhaustive des voies de collaboration fédérale, provinciale pour atteindre les résultats que nous souhaitons tous. In fact, as the Supreme Court underscored today, project assessments and environmental protection are a shared responsibility, which means that the collaborative approaches are not just preferred, they are necessary. I believe all of us want to see the rapid development of a clean economy, an economy that can lead the world in creating jobs and economic prosperity in a low-carbon world, an economy that can create economic opportunity in every province and territory in this beautiful country. The court has provided us with important clarity about the path forward. Let us all use this moment to double down on our work to create the economic, social, and environmental outcomes we all wish to see. Thank you very much. Merci beaucoup.
Thank you, Minister Wilkinson. We'll now open the event to questions. So in order to do so, please raise your hand and I will try to recognize you in the correct order. Please note that you are allowed one question and one follow-up, and you're welcome to ask your question in the language of your choice, of course. Please introduce your media outlet before you ask your question. Alors, nous allons maintenant passer à la période des questions. Veuillez lever la main et j'essaierai de vous donner la parole dans l'ordre. Veuillez noter que vous n'avez droit qu'à une question ainsi qu'à une question de suivi. Vous pouvez poser votre question dans la langue officielle de votre choix. Veuillez vous présenter et indiquer l'organe de presse auquel vous appartenez avant de poser votre question. Great. So we're going to start with Alex Balignol. Alex, can you hear?
I can hear, and I think I'm unmuted. So if you can hear me, I'll fire away.
Fire away. We can hear you.
Okay. I guess just a clarification and then a question. 495 projects. Are those projects currently being assessed by the Impact Assessment Agency? And if so, now that this law has been struck down in part, what happens to all those ongoing assessments?
So no, they're not all in the Impact Assessment Agency. They're at various stages of development, and many are pre-environmental assessment. But certainly there are some that are in the environmental assessment process. We obviously will take into account the guidance of the court in the context of the projects that are currently under review. They will continue in the process, but obviously, our thinking will be informed by the direction of the court. I would also say, though, and I know my colleague Minister Guilbeault may want to speak to this as well, is I was Minister of the Environment for almost 3 years, and certainly in the way in which we implemented the Act and the way in which we thought about the evaluation of cases, it was always tethered to areas of federal jurisdiction. So I don't think that the court's direction is inconsistent with the way in which we've actually been implementing the Act in any event, but certainly that will be top of mind in the way in which we think about the assessment of projects that are currently in the process. I don't know, Stephen, did you want to add anything? Or?
Yeah, if I can, Alex, the law is not struck down. This is not a decision by the Supreme Court. It's an opinion by the Supreme Court, which both Minister Wilkinson and I have recognized it as an important one, and we will make the adjustment suggested by the Supreme Court. But the Act continues to be in place, and we will continue to implement it in the spirit of collaboration with provinces, territories, and Indigenous peoples.
Okay, thanks for that. And just for a follow-up, you mentioned to address the concerns that the court raised about overstepping the bounds of federal jurisdiction, moving quickly for, I guess, new legislation. Can you just clarify what sort of timeline you might have for I guess introducing, if that's the right thing that's going to happen, introducing a new bill to change the current legislation so it's in line with this decision?
I can't really answer that question right now. I mean, we've just received, like you, this opinion by the Supreme Court. There are various paths forward we could use, but we're not in a position. I mean, the introduction of new legislation is one of them. There are other pathways we could use to course correct, because I really think that's what the Supreme Court is asking us to do. They're not saying we can't do that. In fact, there are numerous passages in the opinion where the court says this appeal is not about whether Parliament can enact legislation to protect the environment. It's clear that Parliament can do so under the heads of power assigned in the Constitution and Act of 1867. So I think what the Supreme Court is saying is there are things you need to change, but you can do this clearly. We can do impact assessment federally, and we will continue to do so.
Thank you. Thank you, Alex. We'll move on to another question now from Bob Weber. Bob, you should have the floor if you want to. Oh.
Am I unmuted?
No, yeah, I think we can hear you. You're good.
Excellent. Yeah. Thank you. The court found that the Act gives the feds the opportunity to overstep their bounds. They didn't actually say they had done so. And Minister Wilkinson, I think it was you who said that the application of this Act has been consistent with that. My question is, what will this opinion actually change in the way that the federal government does environmental assessments going forward?
If I can, Jonathan, I think Jonathan said it eloquently, and I'll try to do it justice. But when applying this Act, we have tried to ensure that we stayed within federal heads of powers for the application of the Act, and the Supreme Court tells us this is what we need to do. So we will certainly continue to do that in its application. Now, what the Supreme Court seems to suggest is that the Act, as defined, is too broad in certain respect, and we need to tighten it. So we will work to do that in the coming months.
And let me add to that, Bob. I mean, what I said related a little bit to the experience that I had when I was Minister of the Environment, and I know it's the same with Stephen. But I mean, we've always been focused on areas that touch on federal jurisdiction. Those are important areas. I mean, that includes species at risk. It includes fish and fish habitat. It includes migratory birds. It includes respect for the Section 35 rights of Indigenous peoples. It includes the concerns about climate change. We have always been cognizant of those issues, that they relate to federal jurisdiction, and that's the way we work to implement the Act. The court has said that some of the language in the Act needs to be tightened up and more fully tethered to areas of federal jurisdiction. As I say, we accept that. but it is not inconsistent with the way we've implemented the Act over the course of the past number of years.
Okay, as a follow-up, can you give us, I know it's early days, but can you give us some sense of what the language is that you are going to be tightening up? I mean, is it the language around public interest or social impacts, or where, in your understanding, does the Act need to be tightened?
To provide language at this point, Bob, would be premature. But the Supreme Court did indicate that the notion of public interest was one that perhaps would benefit from being further defined. I think when you read the opinion of the Supreme Court, they seem to indicate that it is very broad.
Okay, thank you. We'll move to another question from David Aiken. David, and just again, reminder, if you could also state your media outlets to everybody. Thank you. David?
Good morning, David Aiken, Global News. Minister Wilkinson, you were Environment Minister, I think, during that first 4 years, 2015, 2019, when your government had a majority government. And the Impact Assessment is the Impact Assessment Act 2019. It took 4 years with a majority government to get that act passed. Are you willing to tell us with a straight face you can get some legislation? Let's think about it here. You've got like basically a calendar year's worth of parliament, and it's a minority parliament. You really think that you'll be able to get the appropriate legislative changes through before the next federal election?
Well, David, with due respect, let me correct you a little bit. I was not Environment Minister from 2015 to 2019. That was
okay.
Catherine McKenna. I was Fisheries Minister for a couple of those years, so certainly, and I was her Parliamentary Secretary for the first couple, but I wasn't the minister. Certainly, when we developed the Impact Assessment Act, we took significant time to do consultation, lots of consultation to try to ensure that we actually got this right. And so it did take significant time before the legislation came before Parliament and ultimately went through Parliament. But what I would say is, when I read the decision of the Supreme Court, it is pretty clear, but it's actually, I think, dealt with. The concerns that are raised by the Supreme Court are dealt with, can be dealt with in a relatively surgical way. I don't want to prejudge the number of amendments that are going to be required, but I think it can be dealt with in a relatively surgical way, such that we can actually move this forward. I think we all have an interest in finding ways to move this forward expeditiously to ensure that we've got certainty out there. We are trying to build an economy of the future with his developing critical minerals and offshore wind and hydrogen production and biofuels production and a whole range of different things. We need to ensure that there is clarity around some of these things. And so it is in everybody's interest that we act expeditiously, but I don't think at this stage, given that the ruling just came out, that we can give a specific time frame on that, but we certainly are going to move as quickly as we can.
Okay, and my next question follow-up from that sort of follows. One of the purposes of this act, as both you and Minister Guilbeault mentioned, was to provide industry, investors, Indigenous people, environmental activists some certainty, clarity, so we could move quicker. The Alberta Court of Appeal ruling was 2022, and it seemed pretty obvious that there was going to be problems with this act. And you could have got, I'm sure you could have got some legal advice that says we have problems. Why had you wasted so much time from 2022 to provide that certainty? And let me put it to you, we're now in another era of uncertainty for industry and investors because your government failed to dot the I's and cross the T's to make sure it was constitutional.
Well, maybe I can just say something quickly, and then Stephen, you probably want to weigh in on this. But I would say a couple things. I mean, the first is some of the presumptions in what you said, David, I just don't agree with. So the Alberta Court also ruled against the federal government on the Greenhouse Gas Act, and the Supreme Court disagreed fundamentally with the Alberta Court's decision. We were of the view that the act was fully constitutional, and we made that case at the Supreme Court. The court has decided that there are areas where we actually need to ensure that it's more closely tethered to federal areas of authority. We accept that, obviously. But I would say that at this point, the act remains in place. We need to ensure that we are making those amendments in an expeditious way so there's clarity about how we actually respond to the court. But the act remains in place. There is certainty for folks who are actually taking projects through. And it is in the interest of all parties, whether it is the province of Alberta, the province of Nova Scotia, or the federal government, to ensure that we actually have clarity for business going forward.
And David, I would point you to a number of projects that have been approved in the recent months. For example, in the area of critical minerals, where Marathon in Ontario, the lithium mine in James Bay, Quebec, where using principles that we've developed through this act, we did the impact assessment in partnership with Indigenous people, which certainly increases the certainty if you're a developer, if you know that the Indigenous communities or nations where your project is going to be developed are on board, and they've supported the impact assessment process and decision. It's a clear contrast to the Harper years, where all of these projects ended up, and in some cases are still in front of the courts, and nothing got built.
Thank you, ministers. We'll now move to another question from Davis Legree. Davis, can you hear?
Yep,
you're good. You're good.
iPolitics. Thanks for taking our questions today. Both of you mentioned that it might be too soon to comment on what any changes to the act would look like, but it seems like a lot of the court's ruling revolved around its concerns with the designated projects list established under the IAA. And I'm just wondering if either of you see a future for that method of project designation, or if it's more likely that we see a return to the rules that were enforced before the act came into place, where projects only trigger the federal assessment process if they require a different federal approval or receive federal funding.
I don't know that, and from my limited after a few hours of the opinion being published by the Supreme Court, limited ability to digest all of this, I don't think the Supreme Court seemed to have taken issue with the project list per se. I think that what the Supreme Court seemed to indicate is that certain definitions or powers in the act as currently written are too broad, and they need to be further refined, which is why I agree with Minister Wilkinson, who said earlier that we believe that we're not talking about rewriting the act. We're talking here about surgical intervention to further define certain elements of it. But my understanding is that the Supreme Court doesn't seem to have taken issues with the project list.
Great, thanks. And just for a second question, I'm wondering, several environmental NGOs intervened on the side of the feds throughout this case, and they clearly think that this ruling that was issued today is detrimental for the environment. And Minister Guilbeault, as a former activist, you guys have framed this as you're almost emboldened that the court has reaffirmed kind of federal jurisdiction in certain areas. But I'm wondering, kind of personally, how you feel following this decision, if you're saddened for what it potentially means for the environment in your view.
Interesting question, David. Listen, I mean, these are complex issues, and when the act was passed, I was not in politics, but it's certainly something I followed very closely. But I would point you to some passage in the opinion by the Supreme Court. One, and I quote, "Environmental protection remains one of today's most pressing challenges. To meet this challenge, Parliament has the power to enact a scheme of environmental assessment." But then the court goes on to say, Parliament also has the duty, however, to act within the enduring division of power framework laid out in the Constitution. So I think this is a good summary of this opinion by the Supreme Court. The federal government can do impact assessment, but they're asking us to further refine certain elements of the act as currently written. So it tells me that we can continue to do what we're doing as a federal government in partnership with provinces, territories, Indigenous peoples, but there are elements that need to be changed. So I wouldn't describe that. I think we can continue doing impact assessment, and that's why we changed the act, so we could take care of issues like climate change, and Indigenous peoples' rights, which were basically ignored under the Harper government years in terms of impact assessment. So we believe that these guiding principles are still valid, and we will continue to move forward with those.
Can I just say one thing? I agree with everything that Stephen said, but I would also say I think folks need to be very careful about the frame that says that the court has somehow decided that the federal government doesn't have an interest in significant environmental areas. That's not what the court said. And if you look at what it said it needs to be tethered more closely to federal areas of authority. Well, the federal government has authority in the area of fish and fish habitat, which is almost every water body in this country. It has authority with respect to migratory birds. It has authority with respect to species at risk, and there are like 700 of those in this country. It has authority with respect to greenhouse gas emissions, which was demonstrated in the Supreme Court decision with respect to climate change. So there are major areas where there is a strong federal interest, and what the court did say was we need to make sure we're tethering it more closely to those, but it didn't say the federal government doesn't have an interest in environmental protection. All of those areas are critically important. All of those areas need to ensure that they are being handled in a sustainable way.
If I can add, Oliver, there is another passage, and I quote, "Characterizing a project as provincial is not a basis to reject the application of federal environmental assessment legislation. Provincial works or undertakings are not shielded from otherwise valid federal legislation." So I think there are a number of elements when you read the opinion of the Supreme Court that clearly reaffirms the right and the fact that the federal government can, and in fact should, be doing impact assessment.
Okay, great. I'm just conscious of time, and we have a number of questions still, and I want to try to get through as many of them as possible. So let's take another one from Ryan Tumulty, National Post. Ryan?
Yeah, good morning. Ryan Tumulty, National Post. I wanted to ask, the court mentions that encourages, I guess, the federal government to work with the provinces on this legislation. Do you have plans as you draft these amendments to work with provinces and try to come up with something that would be acceptable to them?
I would argue that we are working with provinces and territories on these matters on an ongoing basis. It doesn't mean we always agree. In fact, for example, we have an equivalency agreement with the government of British Columbia on impact assessment, and it is our desire to try and reproduce this across the Federation.
And just to that point, I mean, there are lots of mechanisms through which we actually talk about issues around regulatory and permitting alignment. I mentioned the regional energy and resource tables. There's also a Canada-Alberta working group that is ongoing. It's always important that the federal government and the provinces are collaborating and discussing these kinds of issues. One of the key things that we are working on during the process under the regional tables is regulatory alignment, like what Stephen said, in terms of the process of substitution, but also alignment with respect to permitting. So, obviously it is important for all of us. I mean, it's important for the government of Alberta that projects move ahead. It's important for the government of Nova Scotia and Ontario that projects are able to move ahead. And it's very important for the federal government, but it needs to be done in the right way. It needs to be done in the right way because these projects aren't going to get built if they're not done in a manner that is consistent with environmental sustainability and the respect for Indigenous rights.
Okay, just as a follow-up, I mean, the provincial government in Alberta took you to court over this version of the act. They were supported by other provincial governments. Both of you have talked about the importance of developing critical minerals and other assets as part of the green transition. Are you concerned about another delay in a stable regulatory regime delaying those projects that, as you said before, have to be done quickly so that we can get to net zero by 2050?
Jonathan, maybe I can take a first shot at this. I mean, first, as I said initially to one of your colleagues, this is not a decision by the Supreme Court. It's an opinion. So the act still stands and the act still applies. We will obviously analyze it in great care and detail to ensure that between now and when we make those legislative changes. We are applying the act in the spirit in which the Supreme Court is suggesting we should do so. Number one. Number two, I mean, it is interesting we talk about project certainty at a time where the Premier of a province has put a moratorium in place on the development of $30 billion worth of clean technology and renewable energy projects. And at the same time, they're saying we need to provide certainty, which is what we're trying to do. But I think in some instances, I would argue that some provincial premiers should probably look in the mirror when they talk about this question of project certainty.
Yeah, and I would just go back to say, I think a lot of the amendments that would be required are fairly surgical. I think that the fundamentals as laid out in the Supreme Court decision remain the fundamentals that underpin the Impact Assessment Act, and I think that certainty continues to exist. But of course, we want to work with provinces to ensure that we're actually providing the kind of certainty that is going to be required to enable projects to move ahead. I would point to the work that we are doing with Nova Scotia and Newfoundland with respect to putting in place the offshore regulatory system collaboratively to enable the development of offshore wind and the development of a hydrogen industry in Atlantic Canada. I mean, there are opportunities for us to work together if we all, sort of down the rhetoric and we actually try to figure out how to move forward in a way that we all know we need to move forward. So,
thank you, ministers. Again, in the interest of time, we're only about 6 minutes away from when this has to wrap up, but we're going to take, nous allons maintenant prendre une question en français. Alors, ici, j'ai Levasan. Je vais juste essayer de... Est-ce que tu peux m'entendre? Je vais juste trouver le nom exact. Anne Levasseur. Peux-tu nous entendre, Anne? J'ai enlevé le mute. Alors, tu peux parler, Anne? Allez-y. Est-ce que tu peux nous entendre, Anne? Avec Radio-Canada? Tu as levé ton main? OK. Nous allons passer à une autre question pour l'instant. So we're going to move to another question again. We're going to go to Kelly Kreiderman. Kelly, can you hear us? Kelly, can you hear us? Oh, it keeps unmuting and unmuting. I'm seeing that. Now it says it's unmuted. Now it's muted. I'm not sure if this is part of the admin. Okay, it says it's unmuted now. Kelly, try talking. Kelly? Sorry. Kelly, can you hear us? Okay, we're going to have to try moving to another question in the meantime. So I'm sorry, I'm not sure what is happening there. It says she's unmuted. So, okay, we're going to mute her for now. Kelly, if you want, you can send your question to me by email and I will ask it live for you. We'll move to Niall McGee. Please state your media outlet, Niall.
Can you hear me?
Yes, we can.
Yeah, great. It's Niall McGee with the Globe Mail. I'm the mining reporter. I would just like to ask, I think this should be pretty straightforward, hopefully to answer. I talked to a lawyer and he looked at the decision and he said very simply, the big change here is the federal government no longer has the authority to say yes or no to projects overall. So it can weigh in on fisheries, it can weigh in on birds and certain areas, but it can't say yes or no overall to a project. So my question would be, I looked at how many mining projects are under review federally right now. Looks like there's about 25, and there's also 3 road projects into the Ring of Fire. In almost every case, there's provincial EAs that are almost identical. According to this lawyer, those federal studies no longer are essentially valid, and those essentially go away. And so it sort of becomes easier to permit mines because only the provinces really have authority to say yes or no to the overall project. Minister Wilkinson and Mr. Guilbeault, could you just answer, is that read correct? Are we missing anything here?
Do you want to go ahead, Jonathan?
Sure. So I would say a couple of things. I mean, the first is that's an interesting legal opinion, and I think everybody is going to need to take appropriate time to digest what is a long decision on the part of the Supreme Court of Canada. But I would say that the federal government has responsibility in a number of these areas to ensure that our laws are protected. Like the Fisheries Act is a law. You can't just violate it because you don't like it. And so is the Species at Risk Act. And so the federal government continues to have a role, a legitimate role, with respect to whether projects move ahead, and if they do, how they move ahead, and what manner that they actually are going to go about addressing some of the environmental concerns that all Canadians would share. So I don't agree that there's not going to be a federal role with respect to the whole issue of whether projects that do have impacts in areas of federal jurisdiction proceed. What we have said is it needs to make sure that the Act more closely is tethered to areas of federal responsibility, and we accept that, and we will ensure that the appropriate amendments to the Act are made.
Yeah, if I could just follow up on that. Just to be clear, he's not saying the federal government doesn't have a role. He actually agrees with what you're saying. Like you said, fisheries, birds, and a few others that you mentioned. Absolutely, an ability to weigh in and come up with conditions. But he's saying there will be no power from now on for the federal government to say no or yes to the overall projects. So that's specifically what he's saying. Is he correct in that instance?
Well, I think what you have just said in the two different parts is a bit contradictory, right? I mean, at the end of the day, if a project were to essentially not address significant areas of environmental concern that relate to areas of federal jurisdiction, there is no way that the project could proceed. If it simply ignored the Fisheries Act, it ignored the Species at Risk Act, it ignored the carbon emissions associated with the energy that it would utilize. And so I think everybody needs to take a bit of a step back and ensure that we have gone through the decision in a thoughtful and careful way. But certainly the federal government will continue to play a role with respect to the areas of environmental concern and Indigenous rights that fall within the federal government's authorities. And that doesn't change. And to be honest with you, as I said before, the way in which this act has been implemented has been in that manner all the way along.
I echo what Jonathan just said.
Okay, I'm so sorry. We had 2 remaining questions, but we do have to wrap up the press conference. Je suis très désolé, mais nous avons besoin maintenant de conclure la conférence de presse. Alors, je demanderai à les journalistes de nous envoyer ces questions. Please send us your questions, and we can try to respond to them in a very timely fashion to Carolyn and Drew, and for those who were not unable to ask a question because of those technical difficulties. But otherwise, thank you very much, and that concludes this press conference. Merci beaucoup les 2 ministres, et ça maintenant conclut la conférence de presse. Goodbye.
Merci, Olivier.